With our war, actually military operations, in Iran finally at a standstill after over a month of fighting, you may be wondering if any of this was actually legal. The answer is a very interesting case study on constitutional law and statutory interpretation. So, let's find out.
Operation Epic Fury.
The war against Iran.
Iran.
Operations in Iran.
Iran.
6 American service members now killed after the attack on Iran.
As a brief forward, let's get a couple of things out of the way. First, this video will focus specifically on the Iran war, but note that these principles apply to other military operations. The second thing to note is that it is legally not a war. It is a series of prolonged military operations. That is because Congress has not legally declared war on Iran. That would require Congress to draft, debate, and ultimately pass a declaration of war, which is something that Congress hasn't done since World War II. In this video, I will refer to the Iran war interchangeably as both a war and military operations, but just know it is not legally a war. The third and final point to note is that Trump's regime change effort in Iran isn't new. The executive branch has done military operations in various countries like Libya, Somalia, Iraq, and Afghanistan, and each time the president had to justify their operations. Thus, know that what we're discussing isn't specific to Trump, but rather a hot topic that has been debated for the last 20 years. In any case, there are 3 salient areas of the law which may be authorizing Trump to do this war. The first was written all the way back in 1787, the Constitution. There are 2 relevant lines of the Constitution to examine. First is the Declare War Clause of Article 1, which states that Congress and only Congress has the ability to declare war. The second important line is Article 2, Section 2, which clearly delineates that the President is Commander-in-Chief. Furthermore, Article 2, Section 1 endows the President with the executive power to execute his roles. It would follow, then, that in order to fulfill his role as Commander-in-Chief, he must be able to command military operations without impediment from Congress. So then, it seems like the 2 sections of the Constitution are clashing with each other. How do we resolve this conflict? Unfortunately, there isn't one Supreme Court case that can guide us, since the courts have made a point to stay out of the ruling on the legality of military operations. The most known example is the prized cases of 1862, where the Supreme Court ruled that Abraham Lincoln had the ability to blockade southern ports during the Civil War. Yet, this case is not super applicable to Iran, since in this scenario Lincoln was reacting to the belligerency of the South and not a preemptive action like in Iran. Otherwise, there is no major case that the Supreme Court has ruled on which clearly delineates the executive power to make war. Thus, to speculate how the Supreme Court may rule today, we can take an originalist perspective and direct our attention to the founder's intention of the Declare War Clause. On a base level, we should be clear that one of the broadest concerns of the Founding Fathers was being governed by a king, especially related to war. As John Jay, the first Chief Justice of the U.S., put in Federalist No. 4, absolute monarchs will often make war for the purposes and objects merely personal. In England, the king had the authority to declare war and raise armies, among other things. Acknowledging this, the Founding Fathers specifically gave Congress the ability to appropriate funds for the army as well as declare war. The inherent skepticism toward unilateral decision-making, which forms the backbone of Constitution, should be considered when thinking about war powers. However, one of the main points which is often brought up in support of the President's authority is the fact that the Constitution was originally drafted to say that Congress has the right to make war. However, this was later reworded to declare war, which is how it is today. Scholars such as John Yoo in his famous 2001 OLC memorandum have argued that make, as understood by the framers, would be to actually do war, things like organize troops, battles, etc. The switch to declare indicates that the framers wanted the executive to have that power, as they anticipated that Congress would be too slow to act. Furthermore, declare can't be acting as a synonym of make, since the framers understood that by the 1800s, a declaration of war was mostly symbolic. That being said, there are historical facts which contradict Yu's executive theory. For one, many presidents still saw the power of Congress as required to act. In a letter to William Moultrie, George Washington specifically wrote that the Constitution vests the power of declaring war with Congress, and that no offensive expedition could happen until they authorized such a measure. This acknowledgement isn't limited to Washington. Other presidents, such as Madison waiting for congressional approval in 1812, and James Polk appealing to Congress for troops in the Mexican-American War, are examples of early presidents deferring to Congress. Further evidence is found in the writings of Alexander Hamilton and James Madison, who, despite being split on the role of federal government, both agreed that there were some limits on executive power to do war. For Madison, he wrote in Helvidius No. 4 that the power to declare war, including the power of judging the causes of war, is fully and exclusively vested in the legislature. For Hamilton, a large proponent of a strong executive, he still conceded that the president will only have the occasional command of such part of the militia of the nation as by legislative provision. Thus, it's not so clear that the founders all understood Article 2 to be giving war-making power to the executive. Furthermore, it is a telling sign for any constitutional interpretation, as the Supreme Court has stayed out of ruling on it since the 1870s. It seems that the answer may not lie in examining the original intent of the founders. However, that's not the end of the legal avenues to explore. Jumping all the way to 2001, the second area that may offer insight into the legality of the Iran War is the authorization for use of military force in 2001. This was passed after the 9/11 attacks and gives the executive the ability to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or persons. In Trump's initial address on the Iran War, he uses examples of Iran's connection to terrorism. The anecdotes he gives involve the attacks on the USS Cole, October 7th, and their internal oppression of Iranians. We must note, though, that while Trump is correct about Iran's connection with terrorism, it doesn't necessarily mean that the AUMF gives authorization to strike Iran. The AUMF's identification of organizations or persons has long been understood as Al-Qaeda and the Taliban, both of which were not based in Iran during the 9/11 attacks. Furthermore, never has Iran independently been implicated in 9/11. Even if you make the argument that the AUMF extends to all countries which harbored Al-Qaeda or associate or successor groups to Al-Qaeda, the AUMF specifically is written in past tense, harbored, meaning that this only covers groups or countries which harbored Al-Qaeda at the time of 9/11, not countries who currently harbor Al-Qaeda. It would certainly be a novel reading to interpret the AUMF as authorizing action against current-day harborers. Nevertheless, if the AUMF did authorize the US to go into Iran, it would only be to the extent that they go after Al-Qaeda. The executive would not be allowed to go after Iran's nuclear program or do a regime change, which are the two largest talking points in Trump's justification for the war.
This regime can never have a nuclear weapon.
That being said, flimsier appeals to the AUMF have been made. For example, when Obama conducted strikes on Libya, he justified it under the AUMF, despite al-Shabaab not having any connection with the 9/11 attacks. In that scenario, though, Congress actually rejected an authorization for continued strikes. That is in contrast to the Iran War, where Congress declined to give an opinion. Interestingly, though, the War Powers Report submitted to Congress on March 2nd after the Iran strikes does not invoke the AUMF as a source of authority over the Iran War, only the Article 2 Commander-in-Chief powers. Thus, our discussion of the AUMF may be a bit redundant, as the administration has not argued for it in this circumstance. This may change in the future, though, especially if the military operations go on for more than 60 days. Thus, it is important to still consider. There is, however, one final place that we can look to see if this war is legal, and that is the War Powers Resolution. But what exactly is the War Powers Resolution? Passed in 1973 in response to the strikes in Cambodia by Nixon, Congress specifically created a resolution to limit the president's ability to conduct military operations. In specific, Congress wrote, "The constitutional powers of the president as commander-in-chief to introduce the United States Armed Forces into hostilities are exercised only pursuant to a declaration of war, specific statutory authorization, or a national emergency created by an attack upon the United States." Notice that the first two categories are by specific congressional approval, either a declaration of war or a specific authorization like the AOMF. As we've discussed already, it's shaky whether the AOMF really applies here. Thus, the way that the Trump administration has argued that the Iran war doesn't violate the War Powers Resolution is through that third part that was mentioned, which is that there was a national emergency created by an attack upon the U.S. As Secretary of State Marco Rubio explained at one point,
it was abundantly clear that if Iran came under attack by anyone, the United States or Israel or anyone, they were going to respond against the United States.
If we are to accept Rubio's reason for attacking, that would make this a preemptive strike, where we attacked before Iran did. This, however, is in stark contrast to the common interpretation of the third section, where that the executive only has reactionary power, not pre-actionary power. If we were to accept the executive's interpretation, it would vastly expand the executive's ability to start war. All he has to do is prove that there was some threat to a U.S. interest, and they can conduct military operations on that country because those actions would be preemptive. This is a slippery slope which we may not want to tread down. So, to recap, it's unclear and hotly contested on what powers the Constitution gives to the president. The AOMF is unlikely a source of authorization for Trump, but it seems that Trump is not relying on it for his legal justification. The War Powers Resolution could be interpreted as giving authorization, but it would require a novel legal reading that may have adverse downstream consequences. And even if this war could be justified domestically, it is still somewhat contentious since the US must also follow international law. As this video focuses solely on domestic law, this is not a topic we will go into today. Disregarding this fact, however, the final verdict on the Iran war's legality is probably illegal. Unfortunately, this fact won't change much, as Trump has said on multiple occasions that he doesn't think the law applies to him, and the only thing stopping him is his morality. So, what can we do? For one, you can mail your congressman demanding them to strip funding for the war, as that is the main way that Congress can interrupt an executive military operation. Otherwise, simply being informed is the strongest power you could have.